morning, Mr. Pretorius. Good morning, everybody.
Good morning, DCJ. This morning, Chair, Advocate Hofmeyr will lead Mike Brown of NedBank. That will be followed by the expert Dr. Kaufman after the short adjournment. May I just place on record that Alfred Cockrell, Advocate Cockrell, is representing Mr. Brown here today.
Okay, thank you.
Thank you, Chair. Chair, Mr. Brown's evidence completes the evidence under term of reference 1.7. May I request your registrar to swear him in?
Thank you.
Please state your full names for the record.
Michael William Thomas Brown.
Do you have any objection with taking the prescribed oath?
No, I don't.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence you'll give today will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Mr. Brown, you have in front of you a file which we will refer to today as Exhibit H1. If you turn to page 202 in Exhibit H1, you will see a document headed Statement to the Inquiry into State Capture and your name appearing beneath that. Can you confirm that that is your statement provided to the Commission?
That is correct.
And it runs, as I have it, to page 206, where a signature appears. Can you confirm that that's your signature?
That is my signature.
And can you confirm the contents of that statement as being correct?
I can.
Thank you. The statement does go over the page to 207, but that is an annexure, and I will make reference to that in due course in your evidence. Mr. Brown, you also, in matters related to term of reference 1.7, deposed to an affidavit in the Minister of Finance versus Oak Bay matter. Is that correct?
That is correct.
We explained to the Chair on Monday that we have not included the full text of the affidavits in the bundle, but I may well, for the purposes of setting the background to your evidence today, ask you to provide testimony on some of the aspects traversed in that affidavit. In terms of introductory matters, Mr. Brown, can you please clarify for the Chair what your position in NedBank is at the moment?
I am the Chief Executive Officer of both NedBank Group and NedBank Limited, which is the registered banking entity.
And for how long have you held that position?
I was appointed in 2010.
And prior to that, where were you?
Prior to that, I was the Chief Financial Officer and an Executive Director from 2004 up to that date. Prior to that, I have worked for businesses that are now part of the NedBank Group since 1993, and prior to that, I qualified as a chartered accountant.
And so in terms of professional qualifications, is it simply a chartered accountant qualification that you hold?
That's correct. I have a BCom, a diploma in accountancy, and a CASA.
Thank you. So many decades in banking, is that a fair description?
25 years to be precise, and prior to that, I actually spent several years auditing banks.
Mr. Brown, I propose to deal with your evidence really in a chronological order, which will require me at times to move around your statement because it was presented thematically. But for the purposes of today's evidence, a chronological approach will be taken. And so with that in mind, I'd like to start with the events in February 2016. Because as I have it in your affidavit in the Minister of Finance matter, you indicated there that it was in February 2016 that NedBank began reviewing its relationship with the Gupta family and associated entities. Can you please tell the Chair about that?
Chair, that refers to a specific request that I made to our Chief Risk Officer in February 2016 to escalate reviews of the Gupta-related accounts. At that stage, I would have been certain that there were already ongoing reviews taking place within our business units that had the direct relationships with any Gupta entities. But at that stage, it was clear to me that there was an escalation in negative media activity and reporting around the Gupta family and the related entities. And as a consequence of that escalation in media-related activities, I perceived there was an escalation in reputational risk to the bank, and asked our chief risk officer to aggregate the work that was already being done so that it could be presented to Group Exco to enable us to opine on the reputational and business risks.
And then you referred in your affidavit to an event in March 2016, which was a statement by the then Deputy Finance Minister. Of what relevance was that to the work of the bank at the time?
So I think that was of particular relevance in the escalation of negative reporting around the Gupta family. In particular, what made it of particular importance to us was that it was a statement that was issued on the letterhead of the Ministry of Finance, and it contained an allegation from the then Deputy Minister of Finance that members of the Gupta family had offered him the position of the Minister of Finance to replace the then Minister Nene. So for us, that was certainly an extremely serious allegation.
Mr. Brown, you then moved to April of 2016, where certain institutions severed ties with the Gupta-associated entities. Can you explain to the Chair the relevance of those events in early April 2016?
Certainly, Chair. So on the 4th of April 2016, there were media reports, and indeed reports from the underlying companies confirming that both KPMG, who were the auditors to these companies, and SASFIN, who at that stage were the sponsoring broker, had terminated their relationships with the Gupta family. I think from a NedBank point of view, again, these were particularly significant terminations, given that we would assume that the auditor of a set of companies is privy to information that NedBank, who were not the main transactional bankers to the Gupta family, would not have been privy to, and there must have been a reason for them to make their decision. And in fact, the then chief executive of KPMG was quoted as saying that the association risk was too great for them to continue. And while there was no direct quote from the sponsoring broker, I also presume they would have had access to more information than we would have had at that stage.
And what did that lead NedBank to do in relation to the accounts it held for Gupta-associated entities?
So in terms of the process that we followed, we constituted a subcommittee of our Group Exco. That subcommittee was appropriately represented, including myself, our head of risk, our head of legal and compliance, our head of our retail and business banking unit in which these accounts were held, the head of some of the other of our frontline businesses, as well as our group legal counsel. That subcommittee of our Group Exco was mandated to review our ongoing relationships with the Gupta families. That subcommittee actually met on the 6th of April, and in addition to the media that we have spoken about already, during the course of the 6th of April, there were also media reports of both FNB and Barclays ABSA having terminated, and we concluded that Group Exco meeting with the outcome that we believed that the reputational and business risks to NedBank of continuing with our banking relationships would be too great, and as a result, and in addition to that, we also have the contractual right to terminate our banking relationships. The underlying contracts that we enter into with our clients have a notice period. If our clients want to move, they can give us notice and move to another bank. We are also entitled to give clients notice. So as a consequence of that Group Exco meeting, as a consequence of our review of the reputational and business risks, we concluded that we would give contractual notice on the Gupta accounts that were held by NedBank.
Mr. Brown, I'd like to ask you to go to page 1 of Exhibit H1, which is the notice of motion in the Minister of Finance application. You will see on page 1, listed as respondents, a number of the Gupta-related entities. Could you please clarify for us which entities' accounts were held with NedBank and were closed by NedBank with the decision on the 6th of April?
So turning to page 1, Mr. Chair, the first respondent, Oak Bay Investments Pty Limited, was termination was given on the 7th of April following the meeting on the 6th. The 11th respondent, Island Site Investments 180. The 12th respondent, Confident Concept. And the 14th respondent, Sahara Computers.
Thank you. And how long was the termination period given to those entities?
So the termination period was 30 days.
Thank you. And how was that decision of the bank communicated to the entities?
So the decision was communicated in a meeting that was held on the 7th of April. I was not personally in attendance in that meeting. NedBank was represented by people who dealt directly with these accounts, and that meeting was held with a Mr. Nath of the Gupta entities. I'm advised that NedBank's decision to terminate was communicated in that meeting. Mr. Nath refused to accept the delivery of our termination letters, and we subsequently delivered them by registered post. He also asked that NedBank didn't make any media statements around the termination. I think perhaps I'd just like to add, coming back to your previous question, in addition to the accounts that are listed here, the account of VR Laser Services, which is the 10th respondent, was closed by NedBank, but that notice was given on the 4th of May, so it was not part of that first set of notices.
Thank you. Your affidavit in the Minister of Finance matter then referred to the publication of a government announcement on the 13th of April 2016 about the constitution of an interministerial committee to investigate the closure of the Gupta accounts. How did you come to learn of this closure, at least this constitution of the committee?
So I came to learn of it through, I think, two mechanisms. Firstly, there was an announcement by, I believe, Jeff Radebe in the presidency that dealt with the constitution of the IMC, and then subsequent to that when we were invited to attend the IMC.
Thank you. And then on the 14th of April, your affidavit traversed an engagement with Mr. Nazim Hawa, who requested an urgent meeting with NedBank. Can you please tell the chair about that development?
So, having given notice of 30 days for NedBank to close the accounts, in the intervening notice period, it's not unusual for clients to approach the bank to try and have a conversation as to why the accounts should subsequently not be closed. And again, I did not attend that meeting, but I was advised that we were requested to reiterate, to reconsider our decision, which we duly did, and concluded that we would not change our decision to close the accounts.
Thank you. As I have it from your affidavit, where you traverse in the affidavit the events of these meetings which you did not attend, you did provide confirmatory affidavits from those representatives of NedBank who attended the meeting. Is that correct?
That is correct.
And so your testimony today is based on what they have confirmed about those meetings. Is that correct?
That is correct.
I would then like to move to page 205 of Exhibit H1. You will see in the second half of that page a heading, the ANC meeting. And as I have it on the chronology, that is the next event that occurs after the meeting with Nazim Hawa on the 14th of April. You then refer in...
I'm sorry. I think it's the aircon that is making some noise. I don't know whether without it we are going to feel too hot. So maybe if they could see what they can do. I think technicians will see what they can do. If it becomes too hot, we might have to restore it. Okay, all right, you may continue.
Thank you, Chair. Mr. Brown, at paragraph 8 on page 205, you talk about the 20th of April and a request that you received to attend a meeting at Luthuli House. Can you please tell us about that request?
Yes, I received, my personal assistant was on leave at that stage, so the stand-in personal assistant received a request from Edok Godongwana. That request didn't have within it the topic of any conversation, but it was a request to attend a meeting which was subsequently set up by the secretaries, and I attended that meeting on the 20th of April.
Had you been requested to attend Luthuli House before this request?
Yes, I have attended meetings at Luthuli House before. So, for example, when there was national discourse in South Africa on the nationalization of mines, given the importance of that to our economy and the safety and soundness of our banking system, I presented on NedBank's view on that as input into that national discourse.
Had you ever been requested to attend a meeting to discuss the closure of NedBank's accounts with any of its clients at Luthuli House?
No, I hadn't.
And can you tell us when that meeting was held and who was in attendance?
So the meeting was held on the 20th of April. The records that I had after the meeting of my notes showed that Gwedi Mantash and Jesse Duarte were in attendance. It is also my recollection that Enoch Godongwana was in attendance. However, my notes didn't have that, so I am therefore uncertain as to whether he was or wasn't in attendance. He did, however, set up the meeting.
Thank you. And what was the purpose of the meeting? And what was explained to you would be the purpose when you arrived?
So the purpose that was explained to me was to try and gain a better understanding around the circumstances why banks in general close bank accounts. I thought quite deeply beforehand as to whether I should or should not attend the meeting, and my conclusion was that in the environment at that stage, there were at least two key narratives or discussion points. One of them was around the specific matters of the closure of the Gupta accounts, and I was very clear that I would not be able to talk at all, given client confidentiality, around the specifics of the closure of the Gupta accounts. However, there was an intersecting and growing narrative around more general statements around the bank's ability to close accounts generally. What is the legislative environment around FATF and FICA? What impact is this having on investor confidence? And did the banks collude in closing the Gupta accounts? And I certainly felt that in my capacity as the chief executive of NedBank, it was very important that I addressed that second narrative around closure of accounts in general, the legislative framework, the impact on investor confidence, and the fact that NedBank took its own individual decision to close the Gupta bank accounts. I felt that that was incredibly important for the safety and soundness of the financial system in general and for NedBank in particular.
Were you provided with an agenda for the meeting in advance of it?
No.
And in paragraph 9 of your statement, you, from the second line, record there that you were advised of concerns that had been raised to the ANC from the general population and businesses around the ability of banks to just close client accounts unilaterally. What did you say in that regard at the meeting?
So I explained that in the banking system in South Africa, we compete with all of the other banks to try and grow our businesses and actually to open as many accounts as we possibly can. So banks certainly are not in the business of closing accounts unilaterally. I then went on to explain the broad framework around the FIC Act in South Africa. I spoke in particular about Guidance Note 3. I then also, in that meeting, took the attendees through a particular extract from the JP Morgan Chief Executive and Chairman's report around closure of bank accounts to demonstrate that this is not an unusual activity in a certain set of circumstances.
Thank you. You've made reference to the JP Morgan Chairman's report of 2015. That was an annexure to your affidavit in the Minister of Finance matter, but is not part of Exhibit H1. And so I'd like to beg leave to hand that in, Chair. It will be Exhibit H6 with your leave, if I may request your registrar just to take a copy, and also to the witness. Thank you.
Thank you. Well, while you are looking at that, Mr. Brown, you said that banks are not in the habit of closing clients' accounts unilaterally. Whenever they close accounts, certainly I would imagine, based on what I've heard from other witnesses from banks, when they close them in circumstances such as those that prevailed in regard to the particular accounts we are talking about, they do so unilaterally insofar as they don't consult with other banks, so they don't collude. But also they do so unilaterally to the extent that their decision to close the accounts is their decision and theirs alone, in the sense that it's based on their view, and from what I've heard in regard to the other banks, it's not that they will discuss with the client in advance, but it looks like they make an assessment of the situation and make a decision. But after having made the decision, they don't close the door to the client if the client wishes to discuss the matter. But the decision does appear to be unilateral. What would you say to that?
So I would say that the decision is a decision of the bank. It is a decision of the bank, as I said earlier, based on our assessment of business and reputational risk, as well as our contractual right in our underlying legal documentation. And inevitably, what happens in circumstances such as this, and there are many accounts that we choose to close, in circumstances such as this, we give reasonable notice. And it is during that reasonable notice period that the client has the ability to come and talk to the bank about the reasons for closure. And there are certainly instances where, for example, we are trying to complete for a high-risk customer something that's called an extended due diligence that we are required to complete. And if we are unable to get the required documentation from the client to enable us to properly complete that due diligence, we would give notice. If in that notice period the client delivers the required documentation, and that documentation is persuasive in nature, such that the assessment that we had made prior to having that documentation is now no longer correct, we would overturn our decision to close those accounts.
The only reason I was raising the issue of unilateral with you was that I wasn't sure that you were not contradicting what I thought you intended to say by seeming to run away from unilateral. Because as I understand it, unilateral means simply that it's a decision of one party. It's one side, unilateral, it's one side. It's not a decision you take jointly with anybody, with the client or with another bank. It's just one side, and you take it, as I understand it, on the assessment of the situation as you see it in terms of the reputational risk to the bank. But from what I understand, after you have taken the decision, if the client comes forward and wants to try and persuade you to change it, you leave the door open. But it seems to me it remains that it is a unilateral decision in that sense. It's yours and yours only as the bank.
Chair, that is correct, although that unilateral decision is taken by a broad grouping within the bank.
Thank you.
Mr. Brown, just to pick up on an aspect of the Chair's questions, you indicated in the termination notice to the Gupta-related entities that you were closing those accounts because of reputational risk associated with it, with the accounts. And then there was the meeting that we referred to previously with Mr. Hauer on the 3rd of May 2016. Is it your understanding of that meeting that there were not adequate reasons presented by Mr. Hauer at that meeting to remove the reputational risk that NedBank regarded as associated with those accounts?
That is correct.
And can you tell us what that reputational risk really means for a bank such as NedBank?
So the reputation of a company or a bank is essentially how that business is perceived by stakeholders in general. So how we are perceived by clients, employees, competitors, media, investors, regulators, and particularly important for banks would be depositors for the safety and soundness of banks and the system. So probably for banks more than most other businesses, and there would be some that would also fall into this category, and I think here of auditors in particular, reputational risk is extremely important. Our business relies on the trust of members of the general public in the safety and soundness of our bank and the system to enable us to become the custodians of the nation's savings in the form of deposits. So if one thinks through reputational risk, it has inherent in it a level of cascading. It could escalate depending how bad it gets. There is, inevitably certain pieces of reputational risk that would be business as usual, and we would deal with that on a normal basis in the bank. But there are examples of where reputational risk becomes so great to a particular business that has a material and in some instances terminal effect on that business to continue to operate. And I would point obviously to the public examples around the material impacts reputational risk has had on the likes of KPMG and McKinsey's, and the terminal impact that reputational risk would have had on the likes of Bell Pottinger.
Thank you. If I may return to page 206. Chair, was there a question from you? I'm trying to anticipate here.
You are doing well to keep one eye on me. I just want to clarify this. From what you say, Mr. Brown, it would seem to me that your evidence is consistent with the evidence I've had from one, if not more, of the witnesses who have come here and testified about the role of the banks and decisions they took. Now, one of the things they said was that in regard to a specific account holder, you could have, or a bank could have a situation where it considers that it should terminate its relationship with that account holder, not because that account holder has committed or any crime or is in breach of any laws of the country, but simply because there is a certain perception in the public domain about that account holder. Would that be consistent with your understanding of NedBank's position as well?
So, Chair, broadly, yes. However, I would like to amplify a few issues there. There would certainly be accounts that sit on international sanctions lists that would automatically be closed.
Yeah.
And in respect of the perceptions, I think certainly we take a lot of time to try and understand where the underlying news flow comes from, and therefore, as a consequence, how reliable that is likely to be. So if I went back to my previous examples, there's clearly an enormous amount that gets put out on social media that would have a lot less, it would have some weight, but a lot less weight than, for example, a statement coming out of the Ministry of Finance, as we saw in March, or the resignation of auditors or sponsoring brokers.
So it would be a taking into account of everything you consider relevant to the bank's reputational risk, and how much weight you attach to any particular factor would differ from one case to another, with the result that maybe in some case, somebody who has not actually breached any laws of the country, you might close the accounts because there nevertheless is some serious reputational risk. But in other cases, somebody who has not breached any laws but has some reputational risk to the bank, you might decide on balance not to close the accounts. It would just depend on the view you take of everything. Is that right?
That's correct. That's why we manage these decision processes through committees at the bank, which enables input into that decision from a legal perspective and from a business perspective. Perhaps also important to add is that we would not only consider the reputational risk up to that moment in time when we take that decision, we would also be forward-looking in respect of the potential future reputational risk and how that could escalate. And in particular, in respect of this set of circumstances, NedBank was not the main transactional bankers to the Gupta entities, and it would have been a concern to us that if all of the other banks had closed the transactional banking facilities with the Gupta entities, we could have by default become their main transactional bankers and therefore inherited an escalating level of reputational risk as a consequence of that.
Thank you.
Mr. Brown, if we can go to page 206 of Exhibit H1. In the top paragraph on that page, you conclude your description of the meeting at Luthuli House with members of the ANC. And you reference there the Breedenkamp case. How did that come up in your discussions?
So, as I said earlier, in my discussions, I made it very clear that I could not talk about matters related specifically to the Gupta-related accounts. But what I felt was important was that I spoke about the legal framework in general around the closure of bank accounts, and of particular relevance there is the FIC and the related guidance note, as well as the Breedenkamp judgment, which and I'm not a lawyer, but which essentially, in my understanding, said that a bank Standard Bank in that case, is entitled to close the Breedenkamp accounts as a consequence of the reputational risk that Breedenkamp posed to Standard Bank, and in particular what that may mean for its international and other banking relationships.
And Mr. Brown, can you give us a sense of your impression of that meeting at Luthuli House? Did you understand the meeting to be designed to place pressure on the bank to reopen the Gupta-associated accounts?
I did not leave that meeting feeling that I was placed under any pressure to reopen the Gupta accounts. And in fact, the meeting closed with me being thanked for providing information that was helpful in understanding and answering questions that the attendees get.
Thank you. If we can then move to page 202 of Exhibit H1. You will see that there is an introductory section on that page and then a heading, Interactions between NedBank and the IMC. That, as I have it, is shorthand for the Interministerial Committee that you referred to previously. There were public announcements of it having been constituted on the 13th of April 2016. And if you can go to paragraph 2 on that page, talk about an event on the 4th of May 2016 where your executive personal assistant received an email from Ms. Zarina Kellerman. Please can you tell the Chair about that email?
Yes, Chair. It was an email that I received that said, I write to you on behalf of the IMC, set up by Cabinet to look into certain allegations made against certain financial institutions. The IMC consists of the Ministers of Mineral Resources, Finance, Labour and Communications. I've been requested to make contact with Mr. They said William Thomas Brown, but I presume they forgot the Michael, or alternatively a suitable alternate with requisite authority, and request that he makes himself available for a discussion with the IMC on Thursday, the 5th of May, from 12 to 12:30. There is no set agenda for the discussion, but I am advised it is anticipated to be a discussion to gain clarity on the current media reports and public statements made by NedBank with regards to closing the bank accounts and or termination of to the closing of bank accounts and or termination of relationships. Should Mr. Brown not be available person, a teleconference could be accommodated. And then there was some admin around, the dates could move. And finally, should Mr. Brown not be willing to participate, please advise me accordingly so that I may indicate the same to the IMC. I look forward to your response.
Thank you. I'd like to unpack some of the details that you've provided us with there. First of all, the ministers who were identified as constituting the IMC. I'd like us, just for clarification purposes, to identify who the people were who held those ministerial positions at the time. The Minister of Mineral Resources, who was that?
Minister Zwane.
The Minister of Finance.
Minister Gordon.
The Minister of Labour.
Minister Oliphant.
And the Minister of Communications.
Minister Mtumbani.
And can you tell me whether you had received requests like this previously to meet with representatives of government?
So I've certainly received requests to meet with representatives of government, largely representatives of National Treasury around banking and banking system related matters, but I had certainly never received the request to attend an interministerial committee. In fact, I had to try and find out what it actually was.
And when you've had those meetings previously, where have they generally been held?
So I've attended meetings with government in Parliament. I've attended meetings with government at the Ministry of Finance in Pretoria or at the Reserve Bank, by memory.
Thank you. And just for clarification, when you referenced the Minister of Communications, were you intending to reference Minister Mutambi?
That's correct. Sorry, my pronunciation was incorrect.
Thank you. In terms of the notification that was given to you about the purpose of the IMC meeting that you were called to attend, at paragraph 2 on page 202, there is a reference there to the purpose of the discussion being, and I quote here, to gain clarity on the current media reports and public statements made by NedBank with regards to the closing of bank accounts and or termination of relationships. Did you regard that as being a broadly focused purpose for the meeting or specific in its nature?
So I think in the first instance, I regarded it as being quite a strange statement, because I knew at that point in time, NedBank had not made any public statements, given client confidentiality around the closure of these accounts. But I certainly assumed that there would be a conversation around accounts in general. That would have, I suppose I knew that in attending any of these meetings, I would not be able to speak about the Gupta accounts specifically, so therefore I would only be able to provide general input into that meeting.
Where were you told that that meeting would be held?
So the meeting was held at the offices of the Minister of Mineral Resources in Pretoria.
When you provided us a moment ago with your recollection of where you've met previously with members of government, as I recall your testimony, you referenced Parliament, you referenced the Minister of Finance's offices, and you referenced the Reserve Bank. Have you ever previously had occasion to meet at the offices of the Minister of Mineral Resources in relation to banking matters?
No, I haven't.
And what was your response to the request for the meeting?
So similar to the request of the meeting from the ANC, I debated and spoke to colleagues internally about whether I should or should not attend, given some of the strange elements that you have recently alluded to. And again, I concluded that I should attend on the basis that I would not make any statements or references around the Gupta accounts specifically, but as an engaged corporate citizen and as a leader in the banking environment, it was important for me to make sure that I could input into these conversations my views around the bank's ability to close accounts, the processes that we follow generally, the legislative process, to reference the JP Morgan report that we spoke about earlier, and to very specifically point out that there was no collusion amongst the banks in this process. So on balance, I felt that it was appropriate for me to attend. I also felt it would be disrespectful not to attend, but that I would make sure that the conversation was in that second area of the narrative and not the accounts in particular.
And did you regard it as strange that the meeting was to be convened at the Minister of Mineral Resources in Pretoria?
So I did regard it as strange. However, when I was given who the members of the IMC were likely to be, one of those members was the Minister of Finance, who I thought would be the natural go-to person for matters to do with financial services. So I suppose presumed that I assumed he would be in attendance and felt perhaps that was just the most logistically easiest place to get the meeting done on that day.
Precisely who attended was of concern to you, wasn't it?
It was of concern to me.
And so what did you do in that regard?
So prior to the meeting taking place, my secretary emailed as to who would be in attendance, and the first email listed all of the ministers in the IMC, including the Minister of Finance. And then, if you give me a minute to find it, I think there was then a subsequent email to say that as a consequence of it being an ad hoc meeting, they could not at that stage confirm the exact attendance.
Yes, maybe I can give you the reference. If we go to paragraph 3 on page 202,
Yeah.
what you say towards the bottom of the page there is that Ms. Buckley, your personal assistant, confirmed your attendance in an email to Ms. Kellerman on the 5th of May and requested her to confirm that the Minister of Mineral Resources, Minister of Finance, Minister of Labour, and Minister of Communications would be in attendance. And then in the next sentence, which is over the page at 203, you record, and I quote, Ms. Kellerman responded advising that she was unable to confirm exactly which ministers would be in attendance due to it being and I think this is what you referred to, an ad hoc sitting. I'd like to pause there. What did that mean to you?
I suppose at that stage it meant to me that this was either an initial sitting, a sitting that had been set up in contemplation of a number of future sittings that would take place, and or a sitting that had been set up at relatively late notice to get a process going, that it wasn't one that had been planned, meticulously in advance.
And then you go on in that sentence to say that Ms. Kellerman provided assurance that, and I quote, the committee will be appropriately represented. What did you understand that to convey to you?
Well, so I presumed that any committee set up like this would have within its mandate a quorum, and that that when I got to the meeting, that it would be appropriately quorate in terms of its defining mandate.
Thank you. And then further down on page 203 at paragraph 4, you talk about the meeting which you attended on the 6th of May. Can you please indicate who attended the meeting with you from NedBank?
So from NedBank, I was accompanied by Ms. Anna Isaac, who is our Chief Legal Counsel, and Mr. Tico Thomas, who is the Managing Executive in charge of our retail and business banking operations, which is the client-facing business within NedBank that housed the Gupta-related accounts.
And who attended on behalf of the IMC?
So perhaps just give me a second and I will give you that.
If you'd like to look at page 203 of your statement and paragraph 4 there, you indicate from the 4th line who was attending on behalf of the IMC.
So page 203.
Paragraph 4,
Yeah.
and
So,
then
thank
from the end of the 3rd line.
Thank you. So the attendees were Minister Zwane, who chaired the meeting, Mrs. Kellerman, who acted as secretary to the meeting, and Mr. Herbert Mkhize, who joined the meeting as Minister Oliphant's representative, and then 2 other people who joined the meeting but were not introduced, and I assumed that at least one of them was representing the Minister of Communications. Ministers Oliphant and Godin were not present, neither was the Minister of Communications.
Thank you. You then indicated paragraph 4 that you raised a query about the quorate nature of this meeting, and you've referred to that previously. Why was that of concern to you?
I think it was of particular concern to me because I expected, given the nature of the meeting, for the Minister of Finance to be present, given that it is the Finance Ministry that has overarching oversight of the financial services sector and banks in particular.
And what was the response when you raised that concern?
So I was assured by Minister Zwane that the Minister of Finance was aware of the meeting and that we should continue, given his previous response that the meeting was quorate.
Have you gained any subsequent insight as to whether the Minister of Finance was in fact aware of the meeting and had delegated his authority to Minister Zwane for the purposes of it?
So I have no subsequent insight of that other than having read numerous documents, and I believe there is a letter that forms part of one of the bundles from the Minister of Finance where he disputes that.
Right, if I could just take you to that. That is in Exhibit H1 at page 144. That we heard from Mr. Sinton, who gave evidence on Monday, was a letter that was made available by the Minister of Finance in the course of the litigation in the High Court involving the Oak Bay companies and the pressure that had been exerted on the Minister of Finance in relation to securing a reinstatement of those accounts for those companies. If you look at this letter, it is headed from the Minister of Finance, and over the page it appears to have been signed by him. Of course, Minister Godin will be giving evidence to the Commission in due course and no doubt will be asked to confirm these aspects. But for present purposes, you will see at the bottom of page 144 that, well, let's start above. He bullets 5 points there in relation to the constitution of the Interministerial Committee. In the second paragraph, and I quote, he writes, "As you are aware, I was not present at the cabinet meeting you refer to, but I have consulted the cabinet secretariat on the matter. The following emerges," he says, and if you wouldn't mind reading into the record the 5 points that he makes in relation to this cabinet meeting in a letter addressed to Minister Zwane.
So the letter says the following emerges. The cabinet meeting was on the 13th of April 2016, not the 16th of April 2016, which was a Saturday. Point 2, no interministerial committee was established. Point 3, 3 ministers were nominated, Finance, Labour, and Mineral Resources. 4, no one minister was designated as convener. And 5, the financial services sector is not, in quotes, already distressed, close quotes, as your letter indicates, and care must be taken not to compromise financial stability.
And then if we could just take a look at the last paragraph on that page. As I read it, Minister Gordhan concludes the letter with the statement, in the circumstances, it will be advisable for the 3 ministers to first consult on the framework for any discussion with financial institutions. What do you make of that request from the Minister of Finance in relation to coordination with his office for the purposes of engaging with financial institutions?
So I would understand that to be the minister in his capacity as having oversight for the financial services system to, prior to having any engagement, wanting to ensure that this would be a well thought through, pre-planned engagement in the context of the legislation around anti-money laundering, etc.
Thank you. If we can return to page 203, which is back in your statement.
So sorry, just to be clear also, clearly at the time that I attended the IMC, I was unaware of this letter,
Indeed.
Notwithstanding it predating the IMC.
Indeed. Thank you for that clarification. Mr. Brown, you referenced at the top of page 203 your engagements with Ms. Kellerman and her response that she couldn't give you more details about who would be in attendance because she said, quote, it was an ad hoc sitting. When you did convene on the 6th of May, was the meeting introduced as merely an ad hoc sitting of the committee?
I can't specifically recall whether it was introduced as a sitting or an ad hoc sitting.
Thank you. And if you then go down to paragraph 5 on page 203, I'm going to jump ahead slightly in the chronology because what your statement does at this paragraph is it actually jumps ahead to what you did after the meeting. But I'd like to follow its order and then return to what was discussed because we are currently dealing with the theme of who was present at the meeting. And so it's appropriate to deal with what you say in paragraph 5. As I have it, you record the steps you took after the meeting to confirm those who were in attendance. Please can you explain that to the Chair?
So, Chair, as I said earlier in my evidence, there were a number of people in the meeting who I was familiar with. There were also 2 people who were not introduced at the meeting. So I felt it appropriate to get a full listing of who was in attendance so I would know who those people were.
And if we go to page 207, that is Annexure A to your statement. As I have it, that is both your request in the second half of the page. Will you please read into the record what you requested?
So this was requested by my personal assistant, and she requested, please, to Zarina Kellerman, please can you email me the full names and titles of government that attended today's meeting? Thank you.
And then if you look above that, there is the response, as I have it, from Ms. Kellerman on the 9th of May. And what does she record there as who does she record there as the attendees of the meeting?
So, Chair, the response says, apologies for the delay. The team consisted of the following. Mrs. Faith Mutambi, I'll get that right by the end, Mrs. Faith Mutambi, as well as her advisors, Mr. Mzwaneli Manyi and Sandile Nene, Minister Mildred Oliphant, as well as her advisors, Mr. Herbert Mkhize and DDG, Mr. Virgil Seafield, Minister Zwane and his advisor, Advocate Zarina Kellerman, who was the Secretariat.
Was that an accurate recordal of who attended the meeting on the 6th of May with yourself?
No, it was not.
And could you identify the respects in which it was inaccurate?
I can, to the extent that I am aware of that. So firstly, Minister Mutambi did not attend. Her advisor, Mr. Manyi, did not attend. I'm uncertain of whether Mr. Sandile Nene was or wasn't one of the unidentified attendees that I said earlier. Minister Oliphant did not attend. Her advisor, Mr. Mkhize, did attend. I am also uncertain whether DDG Seafield was or wasn't the second person from the prior discussion. And then it was correct in the fact that both Minister Zwane and Advocate Kellerman were there.
Thank you. I'd now like to move to what was discussed at the meeting, and that is at page 203 of your statement, and it commences at the bottom of the page at paragraph 6. Can you take us through in your own words, but happily with reference to what is contained from paragraphs 6.1 to 6.7 over on page 205, what was discussed at the meeting?
So the meeting opened with Minister Zwane advising that the IMC was required to submit a report to Cabinet by the 11th of May, and therefore these meetings needed to be held expeditiously. And off the back of that, I read into the reason for the ad hoc meeting that we spoke about earlier. He also up front expressed dissatisfaction for some banks that had refused to attend. I did not know at that stage if any banks had or hadn't refused to attend, and stated that it was concerning that banks could undermine government by refusing to attend such meetings, and I certainly felt that that was a veiled threat in terms of the power of the IMC. He said that the meeting was a confidential meeting, and I had the impression it was being recorded, given that both the Secretariat was taking notes and there was equipment. I don't know whether the equipment was switched on or not from a recording point of view. Minister Zwane started by saying that the IMC was constituted by Cabinet and that it was not there to represent any particular family or company, but rather to resolve the apparent issues of investor confidence and reported potential job losses that had emerged as a result of banks closing bank accounts, and that those job losses were in thousands. I recall the number he mentioned in the meeting was 16,000. And I certainly up front in the meeting confirmed that while we were happy to engage on matters broadly around closure of bank accounts and legislation, we would not be engaging at all around any specific matters on the Gupta accounts, given banking confidentiality. I then spent a large portion of the meeting going through the regulatory environment, in particular Guidance Note 3, and I listed a number of the issues that exist in Guidance Note 3 around what banks are required to do in terms of knowing their customers, risk rating their customers into high, medium, and low, what are indicators of higher risk customers, and banks' reporting obligations under either cash threshold reporting or suspicious transaction reporting. I also specifically spent time going through the JP Morgan report, where JP Morgan disclosed publicly that they had closed 18,000 accounts in their prior period as a consequence of reputational risk. and also the legal risk they run if they make a mistake.
Mr. Brown, if I may just take you then to Exhibit H6, which we handed in previously. We handed it in at the point that you referred to having made reference to it at the meeting at Latuli House. But here in your statement, you also record that you made reference to it in the meeting with the IMC. We've marked it Exhibit H6. And if you would please indicate to us the aspect of that report that you shared with the IMC.
So, Chair, I would have started on the second page of H6. And if you go just about halfway down the page on the left-hand column, I would have quoted JP Morgan having said that they, during the course of the financial review under review, because this is an extract from their public integrated report, that they deployed new anti-money laundering systems, which is a monitoring platform across all of their global payment transactions. It's now functioning across the company and utilizes sophisticated algorithms that are regularly enhanced based on transactional experience. JP Morgan reviews electronically $105 trillion of gross payments each month, and then on average, 55,000 transactions are reviewed by humans after algorithms have identified any single transactions as being suspicious. Following this effort, we stopped doing business with 18,000 customers in 2015. We are also required to file suspicious activity reports. I presume that is the US equivalent of our STR reporting. And for JP Morgan last year, they filed 180,000 suspicious activity reports, and they estimate that the industry as a whole files millions each year. We understand how important this activity is, not just to protect our company, but to help to protect our country from criminals and terrorists. I then would have continued in particular to say, JP Morgan exited or restricted approximately 500 foreign correspondent banking relationships and tens of thousands of client relationships to simplify our business and reduce our risk to anti-money laundering or AML. The cost of doing proper AML or KYC, know your customer, diligence on a client has increased dramatically, making many of these relationships immediately unprofitable. But we did not exit simply due to profitability. We could have maintained unprofitable client relationships to be supportive of countries around the world that are allies of the United States. The real reason we exited was often because of the extraordinary legal risk if we make a mistake. In many places, and he's talking about around the world, it's simply impossible to meet the new requirements, and if you make just one mistake, the regulatory and legal consequences can be severe and disproportionate. I think what's also relevant is, probably one paragraph further down to say, in all cases, we carefully tried to get the balance right while treating customers fairly. And I certainly felt that that was a very well set out framework for what takes place in banks globally and here in South Africa.
And is it reflective of what happens in NedBank?
Well, certainly the numbers of transactions and amounts are significantly smaller given the relative scale, but it is reflective of what happens in the industry and in NedBank.
Thank you.
With regard to those transactions, are you able to give some picture of how small that scale is in regard to NedBank transactions or accounts which you close, generally speaking, in order to deal with reputational risk?
So I don't have the specific numbers with me, but my recollection is that in the year to June 2016, which was the last data point, 2017, which is the last data point I can recall, NedBank would have closed approximately 100 accounts as a consequence of reputational reasons. There would be a significantly larger number of accounts that would have been closed for other reasons like dormancy, etc.
Yeah. Okay, and I don't know to what extent you may or may not have an idea. Is that close to what you would think some of the major banks also might have, or is it quite too difficult to say in terms of how much in South Africa, how much of that happens in South Africa in terms of banks? I see that maybe in the US it's quite large, but are you able to say, you are not able to say?
So, Chair, unfortunately, I wouldn't have that data for our
Yeah.
competitors.
Okay, thank you.
Thank you, Chair. If we then go to paragraph 6.4 on page 204, and just to locate us, you told us previously in your testimony that when the meeting began, Minister Zwane gave you an assurance that the purpose of the meeting was not to represent any particular family or company, but to talk broadly about issues of investor confidence. Mr. Brown, did he hold true to that assurance?
No, as you see here, the several questions, not only from Minister Zwane, but from also other members of the panel, were also posed into the specific circumstances. There were questions around consistency. There were questions around what had been the triggers for closing these accounts.
Sorry, and when you say these accounts, is this now a focus on the Gupta-associated accounts?
That is correct.
Thank you.
And a conversation that is recorded here about a NedBank staff member talking to a client of NedBank about the Gupta accounts. It's a conversation I wasn't aware of prior to this meeting, but that clearly wasn't in the spirit or in the framing of how this was constituted.
And did you learn how they had come to know of this particular conversation?
I do not know how.
And how did you respond to the allegation that there was a staff member of NedBank who'd spoken to another financial institution about the closure of the Gupta accounts?
So I responded by saying that I was unaware of these allegations, that they were new to me. I then said that the only context that I could think they could have taken place in is a context of NedBank talking to other financial institutions with which we have a correspondent banking relationship. And as a result of our normal conversations, in us doing our due diligence and anti-money laundering reviews on those clients of NedBank, it would be normal to have that conversation. And I said that I would, however, try and understand from when I went back to NedBank as to exactly what the underlying conversation was, which I was able to do, and I subsequently addressed a letter to the IMC that confirmed that the IMC's allegations to us that the NedBank employee was inappropriately talking to NedBank clients about Gupta-related matters was in fact not true.
Thank you. And were the accounts of any other families discussed at the meeting?
No.
If we then go over the page to 205, you then reference at paragraph 6.5 what Minister Zwane then said in relation to the NedBank Gupta entity relationship. Can you please explain to the Chair what he conveyed to you?
So what happened in the meeting is that Minister Zwane referenced that NedBank were not the main transactional bankers to the various Gupta entities. I do not know where he got that information, but he then went on to suggest that would NedBank consider stepping in to save jobs and provide an amicable solution, given that the relevant family had, in the period between when we gave notice and held this meeting, resigned from those companies.
What did you make of that request to you?
I found it particularly strange.
And what was your response to it?
I reminded Mr. Zwane that we were not here to discuss specific client matters.
And if we just go back to his suggestion that NedBank step in to save jobs and provide an amicable solution because family members had resigned from the companies, would that provide an adequate basis for NedBank to reinstate the accounts that you had closed?
Absolutely not.
Why not?
Because our decision for closing the accounts was based on the reputational and business risk associated with those accounts, and that reputational and business risk would not have changed, or not materially have changed at all, as a consequence of resignation of directors. The underlying companies were still in existence and operating.
At the end of paragraph 6.5, you deal with the question of collusion amongst banks. Please tell us what was discussed in that regard.
So my recollection is that there was a conversation around the seeming timing of all of the banks closing accounts at the same time, and as a consequence of that, was there collusion in the closure of accounts? And I refuted that, saying we had not had any conversations with any of the banks around closure of accounts.
And then at paragraph 6.6, you talk about how the meeting concluded. Can you tell us about what happened at the conclusion of the meeting?
So at the conclusion of the meeting, we were thanked for our attendance, and Minister Zwane commented that he found it surprising that other banks had refused to attend the IMC meeting with government, considering that banks receive their licenses from government.
What did you take that to mean?
I also found it to be a very strange statement. I think it felt like a form of a threat. It is also a technically inaccurate statement, because banks do not receive their licenses from government. They receive their licenses from the Reserve Bank, which is constitutionally an independent body.
At paragraph 6.7, you reference that it was agreed that NedBank would be provided with a draft set of minutes for the meeting. Did that occur?
No, we were not provided with a draft or final set of minutes, notwithstanding our request for one after the meeting.
And at paragraph 7, and Chair, this will conclude my questions for the witness, unless there's anything further for you. You talk about your overall impression of this meeting with the ministers at Minister Zwane's offices. What was that impression?
So I think I left the meeting with the impression that the IMC was focused on two key issues. Firstly, to try and determine if there was collusion amongst the banks in the closure of bank accounts. And secondly, to determine whether NedBank would have appetite to step in and become the primary transactional banker for the Gupta Group of companies.
And just for clarification purposes, at paragraph 6.5, the discussion around the relevant family, can you just clarify for us which family that was?
The Gupta family.
Thank you. Those are our questions.
Thank you. Mr. Brown, in that meeting with the IMC, you said that there was a mention of job losses, which were said to be in thousands. As at that time, did you understand those job losses to refer to any specific entity or not? And if your understanding was that they were talking about job losses relating to a particular entity. What entity was that?
So my understanding at the time would be that it was job losses associated with a particular group of entities, being the Gupta-related accounts, and that was an estimate of if the Guptas were unable to have banking facilities and therefore, as a consequence, these companies closed down, that was an estimate of job losses.
Now, when you spoke about the meeting that you had with the ANC, you made it clear that when you came out of that meeting, you had no feeling that you had been pressured to try and reverse the decision of the bank. The discussion had been in general, as I understand it. Excuse me. In regard to the IMC meeting, did you have the same impression?
No, I did not.
And do you want to just articulate again what your impression was as you left the meeting?
So I certainly left the meeting with the impression that a good outcome for the IMC would have been for NedBank to agree to take over the transactional facilities of the Gupta family, something that we were clearly not prepared to do.
And the impression you had, was it one that made you feel that there was pressure being placed upon you, or simply that maybe there was an attempt to persuade and no more than that?
So again, I think this is relatively difficult on a continuum of pressure to persuasion,
that, yeah.
But I certainly felt that the numerous references in the meeting to the licensing regime was pressure that was being placed on the bank.
You see, because it is conceivable that somebody may come before this commission and say that the discussion was intended for nothing more than just a general discussion. That's why I'm asking you these questions. So maybe it might be good if you say, if you just mention all the things or features of the meeting that together may have given you this impression.
So I think primarily the conversation was being led by the chair of the meeting, which was Minister Zwane.
Okay, so maybe my question was not as clear as it should have been. What I would like you to say, and you have said part of it, is just to say what you would say if somebody said, you are wrong to think some pressure was being placed on you to change the decision. I just want you to say, I would stand by that statement if that is what would be the position because of A, B, C, D. Or if you say, look, it's nothing more than my impression, that's fine. I just want to be able to, I just want you to deal with what I think may well come up later on so that we know whether you feel strongly that that was the position or it's just an impression. I just want you to be able to deal with that adequately.
Thank you, Chair. So I would say that what caused me to believe that there was being pressure placed on the bank would have been a combination of the references to the licensing regime and beneath that the subtext around be careful, things could happen to your license if you don't behave in a particular way. And secondly, the closure of the meeting, which effectively was a request for NedBank to become the primary transactional bankers for the Gupta companies, given that other banks had terminated.
Did you say you didn't attend the meeting with Mr. Howard?
That's correct. I didn't attend, but officials from the bank did.
Yes. And I assume they would have given reports to you. Would those reports have revealed that basically in that meeting, the bank did give information to Mr. Howell that it could not give to third parties to say, this is why we have made this decision, and therefore they had the opportunity to say that that's true, that's not true, or whatever?
So, Mr. Chair, my information is that the meeting with Mr. Hauer was a very short meeting. The meeting was concluded probably in a matter of minutes. The intention of that meeting was to deliver the notices of termination, which contained within them the reasoning for termination being, in our opinion, the level of business and reputational risk, and as a consequence, therefore, the termination in terms of contractual clauses, and that initially Mr. Howard didn't want to receive those notices. We actually had to subsequently deliver them via registered post, and his only request was for the bank not to make any public statements, which we hadn't done. So I don't believe we had the opportunity in that meeting to explain more than that, given the very short nature driven by him, not by us.
Okay, thank you very much.
Mr. Brown, if I may just clarify there, and I fully appreciate that it's difficult for you not having been an attendee at those meetings, but the description you've just given about the wanting to hand over the termination letter and the resistance to that, as I have it from your affidavit, was the meeting that was held with Mr. Nath originally. Your evidence previously was that occurred on the 7th of April, and that it was short in the terms that you've described because he was not willing to take over those letters of termination. As I have it, the chair's question related to the subsequent request from Mr. Nazim Howard to meet with the bank. As I have it, that was in a letter of the 14th of April, which you received as a bank on the 19th of April. And then the subsequent meeting with Mr. Howard took place, let me just get my note here, on the 3rd of May 2016. Can you just assist us there with the nature of the meeting with Mr. Howard and what was discussed?
Thank you. Your sequencing is absolutely correct. Apologies. I was answering in respect of the meeting with Mr. Nath on the 7th of April. In respect of the meeting with Mr. Hauer, again, it is difficult for me because I didn't attend the meeting, but it is my understanding that that was a meeting where there was a much broader discussion around NedBank's termination, a conversation around the reasons, and an attempt to persuade NedBank to reverse that prior decision.
And as I have it, the outcome was that NedBank did not retract its prior decision.
That is correct.
Thank you, Chair. And then the final follow-up, just in relation to your questions previously to the witness, in relation to the possibility of further evidence before the Commission. My learned leader at the commencement on Monday indicated that notices to implicated persons had been sent out, flowing from the statements. Those were the statements of Standard Bank and of NedBank, which the legal team viewed as raising implications for persons. And so specifically in relation to Mr. Brown's testimony, due notices were sent to Minister Zwane, and at present there has been no application for cross-examination or any other application from Minister Zwane.
Okay, thank you very much. Mr. Brown, thank you very much for coming to give your evidence. I will excuse you for now. Should there be a reason for you to be asked to come back, the Commission's legal team will be in touch with you and request you to come back. Thank you very much, and you are excused.
Thank you.
It looks like this might be the opportune time. Mr. Pretorius, you want to say something?
No, we understand it's your preference to use all available time, Chair, but in this case, we have to set up overhead projection facilities, and the witness is not here at present. He was due to arrive in time for 11:30 hearing.
Yes.
So may we adjourn may we adjourn for 15 minutes then? Just to allow the setup to take place.
Yeah, 15 minutes is normally for tea time. Are you sure that's enough for setting up?
I'm told so, yes.
Okay, all right. We are at 11:05 now. So let us resume at 11:20.
Thank you, Chair.
We adjourn.